We're good to go.
Russell, I'm Roland Mumford with Mumford.Law, and you and I came across each other when I saw one of your videos. I reached out to you, and this is an opportunity for us to meet each other and introduce our audiences to the other's channel. And I understand you're a YouTuber that has been subjected to police misconduct, and wanted to speak with you about that. I think you're going to show me some body cam, and then I'm kind of going to give an attorney reaction. And this is how I conduct a lot of my intakes with clients. And when they call me and they have body cam, we go through the video, discuss the legal elements, and see if they might have a case. So I really appreciate the opportunity to introduce myself to your channel. And if you can, tell me your full name and what your channel is. Georgia Transparency.
Yes, sir. I'm Russell with Georgia Transparency, and I investigate corruption and police brutality in local governments in and around the Georgia area, also some outside into Alabama, South Carolina, and Florida. And also the link to Mr. Rowland's YouTube channel, Mumford Law, will also be in the description of this channel. So I recommend everybody go over and subscribe to Mumford Law and let them know GT sent you. And
excellent. I'm going to do the same thing. I'll put Georgia Transparency in the description as well. Thank you for saying that. That reminded me about that. So,
okay, so
tell me what's going on. First off, if you give me just a 2 or 3 minute introduction on the issue that you had in that particular county, and then if you want to discuss what happened in Chatham, we can talk about that, and then you're going to play this body cam video. But let's let the audience kind of just give them just a brief introduction, is just kind of the generality of what happened.
All right, so I got contacted by some citizens in Talbot County in reference to the school board and how they're spending money, and the possibility of some misuse of public funds. So I set up a time to meet with these parents at a public library on May 8th and to speak with them. And the outcome from that was, it was very, very positive. I got a big feedback, and there was quite a few people there that wanted to speak to me. So I got to Talbot County about an hour early. And I had to go to the Board of Education anyways to submit open records requests, put in a request to speak at the next public meeting to address the Board of Education about why they trespassed an elderly lady because they didn't like what she had to say at a previous meeting that happened in the past. So to kill that little bit of that time, I went ahead and went to the Board of Education first to submit my open records request. And I have everything documented on video, me submitting my open records request, me requesting to speak at the next board meeting, filling out that form. Then also asking some questions about the finances, the tax dollars. And the lady up front, she offered me coffee. She asked me if I'd like a cup of coffee while I wait. And previous to this, the superintendent's secretary, Joy Andrews, she invited me up there the day prior to meet with her one-on-one. So then when I was in there, just after being offered the coffee a few minutes later, they started talking about what's on the lunch menu. And I was like, oh, I'm hungry. So I was like, how much is it to purchase a lunch plate? So I think she was like $350 or $450 or I don't know, something. But yeah, she's like, yeah, you can go to the cafeteria and purchase a lunch plate. So I'm standing there doing some more, just standing there, documenting, my government and just getting some B-roll footage for the story that I'm going to run with the parents whenever I get there, what they tell me, whatever they want to, give to me. And then next thing you know, I'm bombarded by law enforcement. And that's where the body cam video is going to pick up, is just after the police department came, or the police department and the investigator with the Talbot County Sheriff's Office showed up. And let me know when you're ready. And then this is like Mr. Mumford said, a reaction to what this investigator did.
So if you can, play the video. And then if I hit, say, pause, please be ready to have that mouse button over the pause. And then I want you to stop, because then I'll kind of say, let's look at this and talk about that particular instant motion part of the video. And then after this, we can discuss. I'm going to throw up the lawsuit that I have against the city of Adrian, Georgia, and we can go through that. I can't really discuss the specifics of the lawsuit too much because there's rules about what attorneys can and can't say about a case, but it's public record, but we can discuss the legal argument part of the complaint, and that's universal law. So I don't think there's any issue with that. I do represent a number of YouTubers. As I said, I represent a gentleman in Savannah, Georgia, who's been harassed by Savannah police in Chatham County. That's Malik Jones. He has a YouTube channel. We're getting ready to file that lawsuit against Savannah police, and of course I represent Jason Bennett against Adrian, Georgia. He and his wife, actually. And Jason was reporting on police misconduct, and we allege that he was falsely arrested, and so there's a First Amendment violation and a Fourth Amendment violation. We believe that false arrest was retaliation for his free speech, his doing YouTube content about that misconduct. And then we represent, well, not yet, excuse me, but another gentleman out in Arkansas. We did an interview. If his charges are dismissed, we may be picking up that video where he was just literally merely filming somebody across the street. And his allegations are that person may have been on taxpayer time and maybe using government equipment to cut his yard and maybe that of another person's yard. I believe in that video was actually cutting somebody, one of the city employees or supervisors' yards. But anyways, so that may be a case that we may be filing. And I was also very interested. That's why I reached out. We're about this other young lady that a YouTuber in Georgia who you had done an interview with. If you want to speak about that for a few minutes at some point in this video, that's fine also. But I was particularly interested in possibly assisting her also. So let's play the video and let's take a look at this.
All right, so this is right when the Talbots, the chief of police from the Talbotton City Police Department and investigator Richard Kurt Owsley showed up on the scene inside the Board of Education.
All right, great.
For myself, I'm an independent journalist.
First Amendment on it.
Okay.
You got some idea on it?
Now let's stop right there.
Yeah.
Now, who said First Amendment auditor? What is he saying here?
He's referencing to the chief of police that I'm a First Amendment auditor.
So right there, immediately, that develops, what is that phrase, contempt by cop? So right here, you're automatically being targeted as a YouTuber, as an auditor, or as somebody that everybody now with a camera is a journalist. And a lot of these government officials, they think that you have to work for a TV station or a radio station or other legacy media to be, quote, be a credentialed press member. Well, according to that logic, then if you went back in time through a time machine and you had a TV channel camera, and in 200 and some years ago, they were using a printing press, they would say that news camera, that news reporter was not credentialed. So the ignorance of government officials today about what constitutes a journalist under the First Amendment is just plainly ignorant. Anybody in any manner that can communicate information to the public about something that is newsworthy or that has a value to the public is a journalist. And I think to a degree, we're all journalists. So I think right here, this automatically sets the contempt that this officer has for YouTubers. And that would help in a case that you have because it already goes to the discriminatory animus. Let's play.
First Amendment on it. 911 dispatch said that you are making them nervous. We are conducting an investigation. You're not part of that investigation. Give me your ID or you go to jail.
Okay. All right. I'm going to reach my back pocket and get my identification.
Absolutely.
Well,
All right, now let's stop right there. What is it that they thought that these clerks thought you were doing that that they caused them to have fear?
I'm still trying to figure that out today.
So this officer knows that in order to create, quote, suspicion, I think he manufactured that issue about clerks being fearful, because then he wants to go and create what you have to ask for ID is arguable reasonable suspicion, or excuse me, arguable articulable reasonable suspicion. And I think he's manufacturing that in this instance. There was no reason here for him to ask for your ID whatsoever. I'm litigating a Section 1983 case right now involving if you have to produce ID to an officer, and that's in the federal court, the Savannah or Brunswick district, Southern District of Georgia, and we actually have oral argument on their motion to dismiss on August 11th. So right here, there was no basis for, in my opinion, for him to ask for your ID. But let's go ahead and play.
Just step outside when we get later in traffic. Do you have any weapons or anything you need to know about?
No, sir.
Did he come under any metal detectors or any security system before he entered this building? Okay. You don't know that.
Oh, no, sir, you can't take my camera.
Take the camera and we'll put you in jail for obstruction.
Okay.
Hold this, chief. Turn around, put your hands on the law, I'm going to pat you down for safety.
All right, let's stop there. Yeah, there was absolutely no legal basis right here for him to do a Terry. This is what we refer to as a pat down, a Terry search, or the Supreme Court case. This is absolutely inappropriate. Who else is walking through that door? Did he pat them down?
I was the only one that got patted down when I was there.
Now, is this the door that everybody walks through to enter the building?
Yes, that is the door, and where I'm in right now is the public lobby to the Board of Education.
And did you have a purpose for going into the school board that day to get some records?
I did. My purpose was to submit open records requests. The
lady that just walked through in that video, do you know if she was an employee?
I'm not sure. She could have been.
Okay.
I don't.
Do they have any kind of security screening right there at the doorway?
No.
So anybody can walk in and out of that school board building and there's no security for them to go through?
No.
Okay. And so why is it that he's searching you? Why is he patting you down?
I'm confused about it today as well. I don't know.
It's real simple. He's violating your rights. He's intimidating you. And there was absolutely no basis for obstruction here. And before you had given him that ID, I probably would suggest, as many other YouTube auditors do, is you say, if I do not give you my ID, am I going to be arrested? Because then what that does is that will trigger making a 1983 lawsuit actionable. And then if you give him...
Well, he did say that. He did.
Oh,
he did.
Okay.
No, he did, because I said, I said, what reason do you believe me? He goes, give me your ID or you're going to jail.
There you go. So that would make that actionable. Let's continue the video.
Okay, worried about what's in my phones and my pocket and my wallets and my piece of security, you said, you know, here, you did say he was looking at employees and this is what they come up. This is an investigation. I'm going to
Yes, I'll leave. Can I leave?
Let me ask you this. During this time, did you record your interaction with the clerks?
I recorded my entire interaction with the clerks with the camera that he's holding right there.
So if he alleges that you were making the clerks or these employees feel uncomfortable, or that you had demonstrated some disposition that would cause a reasonable person to fear for their safety, you have all of those interactions recorded. Is that correct?
I do, yes.
That is absolutely crucial. And if there's any other people out there that want to be YouTube auditors or are in fact auditing, you need to, I understand you guys go into these buildings and you're holding up your camera, there's two suggestions. One, you need to be live streaming either on Facebook. There's other apps that you can use. So that way, if the police take the phone, that video is protected, because these police absolutely delete videos. There's numerous examples of that. The second I would say is get you a little Insta360 camera. They're literally the size of my thumb, and have that where you can wear it with clip it to your shirt, and have that as a backup recording device, as well as the main phone, your main recording device. Another thing that people do is they use those Ray-Ban sunglasses or glasses that record also. Long Island Audit, he does that very often. So I'd offer that suggestion. But let's go ahead, and I think you have a case here just from what I've seen right here. But let's keep playing the video.
This is when I went live on my channel.
Oh, okay.
The lady on the right with the ball cap, she's the chief deputy, Mamie Sanders. She's right under the sheriff.
Okay. Well, let me tell you why that may be important, is because if you got the chief deputy right there on scene and she's ratifying his conduct, then that may possibly build the basis for a Monell claim. Now, in a Section 1983 lawsuit, as most people know, you sue the officers in their official or their individual capacity. If you sue them in their official capacity, you have in essence also sued the police department. I always name the officers individually. That's an individual claim, and that claim is subject to a qualified immunity defense. If you sue the police department, well, you wouldn't really be suing the police department, because in most instances they don't qualify as a governmental entity. You would be suing the municipality that is over the police department, pays the police department, and so forth. And that's where what you refer to as a Monell claim. And there, that is, you have to establish that there's a policy, practice, and custom, which is very, very difficult to do. But in some instances, you can try to establish that a failure to train argument or a ratification of the misconduct argument. And here, with that deputy, chief deputy, who should know the policies and be better trained than anybody, if she's allowing this conduct to occur, then you could possibly have a Monell claim. You could also sue her individually for supervisory liability claim. That's what I have in my case in South Georgia. We sued a supervisor that showed up on scene. There, though, they have to be involved with the officers that are perpetrating the misconduct. They can't just be a bystander. They have to be participating in the misconduct to some degree. All right, let's keep playing.
Which she did participate into it, because she told the employee of the school board to have me removed.
There you go. Did you hear that there? He said lack of warrants.
Yes.
That is why police officers want to take your ID. They're not investigating you. When they ask for your ID, the law says that they have to be doing so to advance the purpose of their investigation. When cops are asking for ID and they know, in fact, that you're not committing a crime, it's to see if there's any outstanding warrants. That's why they do it. And the reason that police officers in the state of Georgia are abusing this request for ID. They know that Georgia is not a stop and ID state. However, the loitering and prowling statute has this little sentence that says that failure to identify oneself may, that's the verb, may be a factor to arrest somebody for loitering and prowling. However, the courts have said that you take a totality of the circumstances approach, and the major factors in that loitering and prowling are actually is the person fleeing, and are there other observable objective facts that a person is committing a crime. So they abuse that loitering and prowling statute. That's the little gateway they try to use to ask you for your ID. But the statute doesn't say provide identification. It discusses a person identifying themselves. But anyways, that's why I wanted to point that out. Let's keep playing. Let's let it play and go for some time here.
And now, so I was going to leave. I wasn't going to leave until so she asked me, I'll leave.
Go talk to the person you call and complain about suspicious activity. People know this. School, children, we're going to protect children first. Step on toes of a certain child. That's not violating people's rights. That's protecting the lives of children.
What did he say? He would step on what toes?
He would step on people's toes to protect the lives of children, but there were no children present here.
Was this a school?
It's the Board of Education. I
understand it's a Board of Education office, but is it attached to a school, or is this?
It's attached, like this. Well, this building directly in the back, that's like one of the school buildings.
You may want to put a link in the description to maybe the video where you're interacting with the employees to show. That would be a suggestion I would give. But go ahead.
Okay.
Children here. Your ID badge.
Tons of icons down.
Yes. I'll be right back.
Am I still detained?
Yes, and these three are going to watch you while I go inside to talk to the person who called and complained.
But you said I haven't committed a crime. Why don't you detained?
Until I conduct and conclude my investigation, you are detained. You will be detained for a reasonable amount of time until I get to the bottom of this. Please, sir.
You can hear, you're being very professional here. You're not raising your voice. If there's anybody that goes out and does what Russell does, do not be the bad guy, because if you want to have a lawsuit, you got to remember there's going to be a jury that needs to like you. And a lot of times I've turned away cases where the case had merit, but because of the way the person was acting, cussing at the sheriff at the gas pump or whatever the other cases I may have looked at, you can, just because the law says you have free speech to go cuss a police officer and you're trying to get a reaction out of them, you may have a case on the merits, but it doesn't mean a jury's going to give you any money. They may give you nominal damages, which would be $1. And so you need to remember that you want the jury to like you. And here you're acting in no manner that any reasonable person could consider as threatening. You're not being obstinate with him. You're not being disrespectful. You don't even raise your voice at any time. Your inflection and disposition is professional, but he absolutely has contempt for you. He raised that auditor word immediately when he ran into you, and he may have had some previous run-in with auditors, or maybe he watches YouTube. I don't know, but he clearly has a contempt for people that are exercising constitutionally protected activities such as you're doing here. And so I commend you on how professional you're being, and you're asking very good questions here. Am I still detained? Because you always want to ask people, am I free to go? Well, let's keep playing.
The trip says he wants some already.
Okay. I don't. Tell me what you just said to me.
Dr. Cotrette would like for him to be arrested and taken off campus.
He harassed me terribly on the
Yes,
phone
yesterday, and he posted on social media. Yeah,
Okay.
I'm over here. Okay. Hey, Captain, Chief Jason. The gentleman called yesterday. He called all through the school until somebody answered the phone. And it's Dr. Cattreth, secretary. I did answer the phone. And he harassed and all that. I just told him I wasn't going to answer any more questions. And I was talking with him. The lecture, so to speak. And then he posted it on social media. And since then, it has been very harassing students about the school and about
All right, let's stop right there. So she says that you called the day before. You have a video on your channel, I presume, about this interaction.
Yes.
And I'm assuming you dispute the characterization of this call, correct?
Oh, 100%. I wasn't harassing her. We had like a 10-minute conversation. And then towards the end of that conversation, she invited me up to the school board to meet with her one-on-one.
Are you serious?
No, I'm dead serious. No, it's on my channel. I got the phone call. If you want me to play that
She's
right now.
standing here accusing you of harassing her the day before on a phone call. Apparently, someone, she wants you arrested, or somebody here is saying to have you arrested, but she invited you to come to the school to speak to her.
You mean play a portion
And
of
then
the you mean play a portion of the phone call? It's like 2 minutes. It's got it in it, or a minute.
Yeah, let's do it. I just find that absolutely hilarious. And the fact that she brings up the fact that you posted the video and that it got some number of views, that helps your cause. That shows the animus behind why they're asking you for you to be arrested.
This is a portion of the phone call with Joey Andrews, and let's see how harassing I'm being.
Oh my God. I'm sorry. That's incredulous.
There's no correction going on. Okay, no correction. No correction going on. Oh no, that was about the gross salary. These are just generalized questions. I'm working on the story. Oh yes, ma'am. Yes, ma'am. I'm concerned, and then and the reason why I'm saying that because I want to come in on the 20th, and I want to address my royalty that's there, being the superintendent, the school board members are royalty, and us peasants down here at the bottom of the totem pole. Oh, okay. Is that okay? Yes. It's not okay to ask you any questions? Oh, they do it over the phone all the time, don't they? Oh, why doesn't Joey do it? Doesn't Joey work for the people? Oh no, man, you work for the people. You're paying tax dollars. We can do it.
Right there.
Yeah, I don't know who you are. Tax money pays your salary. Can we not pay you a salary since we don't know who you are? Let's get no tax money. Incorrect.
Yeah, that's it.
So you're challenging her to a degree, but there was nothing inappropriate, unprofessional, threatening, harassing about that in any way.
Well, the phone call was about 11 minutes. It was about an 11-minute phone call, and it was just the extent of that. The same way I'm talking to you.
But is the entire 11-minute phone call on your channel a video?
No.
Okay. Well, that's your decision what you want to do with that. But in fairness, to support your argument, if you're saying that you didn't harass her, then you may want to post that online, but that's your decision what you want to do. But based on what I've heard in that clip of that phone call, I didn't hear or see anything. But now this 11 minutes that you say, this last two, was that the end of the phone call right there?
That was right towards the end of the phone call.
Okay, well, the fact
Yeah.
that, so I'm assuming there's about 8 minutes or 9 minutes of a phone call.
Something like that, roughly. Yeah.
Very good. So therefore, if she's saying, why don't you come down here and talk to us? And that was at the end of the phone call, and we haven't been able to hear the first 8 minutes. The fact that she says, why don't you come down here? Well, if she was so fearful for her safety, if she feared for her safety, why would she make that statement? So that tells me that you didn't do anything threatening in the first several minutes of the phone call. Let's play the rest of the video.
He made some of them. I kept referring him to our attorney. He did apparently reach our attorney, Mr. Maurice King, and then he criticized Mr. Maurice King on social media. Mr. King was a different.
He's not going to be charged. Dismissed justice. He's going to be charged because he upset me. He disrupted me. He instantly went out. I am here to protect the children.
Yeah, people.
She thinks it's still the See, you're.
He's leading these people here. He's practically putting words in their mouth, but go ahead. And I've seen that in a number of cases. I just did a video. If he gets all his charges dismissed, I'm going to be representing somebody that has a YouTube channel. He was just merely sleeping in his car parked at a gas station. And that officer was literally went inside the gas station to solicit a trespass from the gas station clerk and was putting words in her mouth, which were the elements for a trespassing charge. And you can almost tell she was just sitting there sort of like nodding her head, kind of going along with what he wanted. But she even said in the video, well, he hasn't come inside. He hasn't really been bothering anybody. And then after this officer was putting words in her mouth and leading her, what we would say in court, asking leading questions, she was sort of like, oh, okay, I'm going to go along with this. And I believe to an extent that's what's happening here. Go ahead.
At face value, he's a First Amendment officer. He's going to come with a camera. But while he was practicing his First Amendment audition, he shook people up. Didn't leave when he was out. The police were called. I heard over the radio. Nothing suspicious, and people were shook up.
Yes.
That's just what he did.
Yes, please.
I would have to see the video of how you were interacting with the people to give any opinion on that, but go ahead.
Say
Joy, Joy. Last name is Andrews, Andrews.
Andrews.
Yes, sir.
You ready, birth?
9/6/1957. The one on that. A very good
joke between you and because you have good
7/6. 3, 2.
you have usually scare way
Share.
who was where
John was legal name is James. John. James CATTT.
One six. All right, my next course of action is on the county. Secure example. 8 signatures. We did you have that. See that. Okay.
Thank you, sir. Thank you, Chief.
Let me stop right here. Have you done an open records request or through your case gotten the statements that he asked them to write?
Funny about the open records request, which I'm getting ready to file another
They're going to
lawsuit.
claim an investigation exception, but I think they have to give it to you being the defendant.
They're not responding.
Well, you're entitled. Well, it depends on where. With this being a misdemeanor, there's a question of whether they have to produce discovery to you. Now, if there's a trial, they have to produce the documents, obviously. But, and if a person submits an open records request for those statements or any documents regarding these charges, they're going to claim an investigation exception or that the case is still being prosecuted. And that is an exception under the Georgia Open Records Statute.
Well, they're not even doing that. I'm not getting a response from them at all. I put 5 open records requests into Talbot County Sheriff's Office, and they're not even responding at all.
And you don't have a criminal defense attorney?
No, not criminal defense, no.
Somehow you need to get these statements because he's telling them to write them out and to compare what they say to the video that you have, and obviously looking for misstatements or any falsities. And that's something, but let's go ahead and play.
Somebody brought up to me that there's a big no right here, is that he didn't separate the witnesses. He should have separated them and got their statements.
I don't know that there's a law about that, but that may be a policy. So I did a video last week about what policies to ask from a police department if you want to represent yourself in a lawsuit. And I went through all the different kinds of standing orders, or what we call standard operating procedures. So one of the things that you would want to look for is, what is the policy, the standing order on taking witness statements? And I bet you, usually in most SOPs, you are correct that the proper way to do it is you would separate the witnesses and then each of them speak on their own so that they're not conferring with each other to compare their statements. And that's how you would almost sort of treat it as a crime scene, so to speak. What is in their mind, the mental impressions that they formed, in essence, is sort of like a crime scene. And you don't want one to have I'm trying to contaminate the other, so to speak. You don't want one, hey, what do you think about this? Did he say that, or did he not do that, et cetera? But what's funny is that when police officers aren't being investigated, maybe there's a shooting on scene or an extreme use of excessive force, a lot of these police unions will negotiate into the contracts that during the first few days before they do their, I believe it's what they call it, Garrity interview, I believe is what they call it, but that the officers can confer with each other and to make sure they get their stories to match, which is completely inappropriate. That their statements should be taken separate and independent of each other. But let's go ahead.
That's okay. He's allowed to record. Okay. You're under arrest for this one.
So is this a friend of yours that's there with you, recording you?
I'm sorry?
Who's recording here? Is this the body cam, the police?
This is the Talbotton's body cam, yeah.
So they gave you the body cam?
Yes.
But they're not giving you the witness statements?
I haven't asked for the witness statements yet.
Oh, okay. Well, I thought, okay. Well, you need to demand every document.
It's a separate, they're separate agencies. The Talbotton Police Department recorded it with their body cam video. The Sheriff's Department didn't have any body cams. So I got this body cam from the city.
What was that first part? Who had the body cam?
The city of Talbotton had the body cam.
Oh, that's a city police officer.
That's the chief of police that's recording it with his body cam.
Oh, and then this gentleman, does he work for a sheriff's department?
Yeah, this guy here, he's the one that's arresting me. He's an investigator with the sheriff's office.
Okay. Is there a reason why it's a sheriff's department employee arresting you?
I got the radio traffic and the 911 call. The radio 911 dispatched this call to the chief of police because he was inside the city limits. You hear the investigator come up on the radio and say, "Hey, I'm coming with you to back you up." So he was never actually called here. He just tagged.
Now that's another important policy document that you want to get. I discussed that in my other video. You want to get the SOP on what they refer to as mutual aid. There's a case I'm looking at in South Georgia right now where it was a sheriff's department and detective off duty, and I use the word conspiring, but he's working with a Homeland Security Department employee, agent, etc. So we want to get the policies on that, and I believe we just received them on mutual aid or how one department assists another in terms of inter or intra-jurisdictional issues there. But I would definitely want to get the policies on mutual aid, or when two different law enforcement departments are working together on scene. Another example of that is I had a false arrest DUI case, but it was a city police department police department officer that was following the gentleman, but that was, I guess he was on his way home and they let him use the police car for privileges. But the jurisdiction where the stop was for the alleged DUI was outside of the city, and it was in the jurisdiction of a county. And so then a sheriff's department employee or a deputy shows up on the scene, and then he conducts the field sobriety test and arrests the gentleman for DUI. But that gentleman involved in that was special needs, and it was a false DUI arrest. His blood came back 0, and those charges were all dismissed. But anyways, so let's go ahead.
Okay.
I've been arrested a couple of times.
Yeah, you're kind of a big fella, and you haven't been physically disruptive. Put your hands up from like you're praying. Can you put your phone in your pocket or secure it somehow?
And that's important there that he says you have not been physically disruptive. I think that's an admission on record about your disposition here that helps you. Go ahead.
Being arrested for this conduct. Got several witnesses. You shook them up. You disrupted their work. Okay. It's a public building, but you disrupted citizens. You disrupted their work. Okay. I had 2 females that said they were scared. Okay. Underground discipline.
I'd really like to see that video, but we need to keep this. Maybe we can do a second video, part 2 on that.
Yeah, it's about a 40-minute.
Yeah, that's way too long for this. Let's go ahead. Well, he's showing you some courtesy and respect here. That's interesting. He's letting you keep recording the phone. Oftentimes, they'll try to stop the phone or delete.
Wait until the second part of this video. You're probably going to laugh. You're going to laugh in a minute.
All right.
Jay?
I mean, that's courteous. Because a lot of times they'll use that towing of your vehicle as additional retaliation. But go ahead. If you want to scroll, that's fine.
Do what?
If you want to scroll a little forward, that's fine. Is it from here? Does he just pretty much arrest you and that's the end of it?
Well, we have a conversation, and I don't know if you want to hear it. It's like a couple of minute conversation.
Yeah. I think I've seen that. So he pretty much arrests you here and then you bond out and that's the end of it, correct?
Well, here's a funny part here. Hold on.
Okay.
Let me get to it.
Yeah, absolutely.
So this is the body cam video. So I'm going to pull up the live stream video from this part right here, because it's not on the body cam, it's on my live stream. So let me go. Let me grab the Talbot County arrest. Okay, so here's the live stream. So let me go.
County Board of Ed.
Clue.
Okay.
I have 2 females that said they were arrested for. Now,
But if it doesn't,
right, or you'll have a right. To tell
Okay, so right
hey, you
here,
know who I'm talking to on here? Get a hold of the attorneys.
this is like where it continued on from the body cam.
And your camera.
It goes up to. Yeah, yes,
Let me
sir.
buckle you in.
Oh, I'm county school
So I live streamed my whole ride to jail.
board of education.
How were you able to hold your phone?
I was like this.
Oh, he handcuffed you from the front?
Yeah, he handcuffed me in the front, and I was just kind of like,
Well,
holding
that's
it.
not. Well, hey, that's nice that he did that. I mean, it sucks to be arrested, but I would prefer to be handcuffed from the front, not from the rear. But go ahead.
Yeah, for disorderly conduct. Check.
You may
Off.
turn it
Okay.
off, you may turn the phone off, whatever
Okay.
you want to do.
All right, guys, Talbotton County, Georgia, and Talbotton, Georgia, at the Talbot County Sheriff's Office. Get a hold of the attorneys. Have a good day. I'll be back on when I get out.
All right.
So that was it in a nutshell. But he changed the charge from disorderly conduct. He went and got a warrant for loitering.
Okay. Loitering. So let's look at. I have briefed that a number of times.
One second, I'm going to see.
I'm going to bring up that statute. So I'm going to share the screen and let's take a look at that. All right, do you see that?
Yes.
So this is the loitering prowling statute. I know it backwards and forwards. A person commits the offense of loitering or prowling when he is in a place, at a time, or in a manner not usual. And they in the pleadings, they make a big deal about this issue, are not usual for law-abiding individuals under circumstances that warrant a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. Now the question is it not usual for a person to come in to a government building, a school board office, and request records? I don't think they're going to be able to make that argument based on what I know. Again, I haven't seen the video of your interaction with the city clerks, so my opinion could change. But if you're representing to me that you did not, if you acted the same as you did with him, if you acted with the clerks the same way you did with him, I don't see how you would have acted.
No, I did. I acted as I was the same way with the investigator that I was with them.
And then right here, among the circumstances which may be considered in determining whether alarm is warranted is the fact that the person takes flight upon the appearance of law enforcement officer. Clearly that didn't apply here. And this is where they abuse the ID statute in Georgia, because it's not a stop and ID state. There's no law that says you have to produce ID. But that's why they always bring up this loitering and prowling, because this little language right here, refuses to identify himself. But that doesn't say show identification, or manifestly endeavors to conceal himself or any object. The rest of the language, then a person committing the offense of loitering or prowling shall be guilty of a misdemeanor. That I don't see that based on what you've represented to me. I don't see it. Now, again, I haven't seen the interaction between you and the clerks, and I'd need to absolutely see that. And compare that. Well, I don't care what's in their written statements, because if you have video, particularly if you guys are doing this kind of stuff, get a camera that has a time and date stamp on the video so a person can tell if it's been edited. So anyways, that's the statute. Let me
I wanted to show you this. I wanted to show you this here. What the narrative. I wanted to read the narrative in this warrant. If you can see it.
Yeah, just share it.
Yeah. Okay. So Russell Clarence Pickering did violate when he received knowingly disrupt and interfere with the operations of public school by entering video without reasonable justification and causing several employees who were in charge of the general duties of protecting the 380 minor children who were present on campus during the school hours. This disruption distracted employees who are also charged with safety and security of minors. The acts compromised the children's safety and security and safety. There were several witnesses, school employees, who stated they were frightened and highly distracted in performing their designated operations. The suspect claimed to be a journalist, but had no ID to indicate nor such arranged appointment for conducting any said journalism.
So let me get a shout out to a channel, Random Patriot in Arkansas. He was falsely arrested, and he was able to cover a large portion of his criminal defense attorney's fees, as I understand, as he said on video, from people that donate to his channel, either Cash App or Venmo or Zelle or any other basis. if you can support Russell with a donation and he puts some information about a way to receive funds, I'm just making this as a suggestion. And if that's something you want to do, Russell, a lot of YouTubers do that. YouTubers need to be doing that on their channel, getting help from, because that's one way that citizens can fight the system, is by supporting you with donations so that you can get a criminal defense attorney. And I'm sorry that you don't have one. I don't know what if you're able to,
Well, it hasn't been filed
yeah.
yet. The case hasn't been filed. It hasn't, the accusation hasn't been filed yet with the DA's office.
Well, how long ago did this happen?
It happened on May 8th. So,
Well,
like maybe almost 2 months.
Well, I don't know why it's taken them that long to do it. One of the other things that I see in Georgia is that, let me just, for example, I'm transitioning from Nashville, Tennessee to Savannah, Georgia. 80% of my cases are in South Georgia, but I take cases in Arkansas, Tennessee, and in Georgia. In Tennessee, if a person is arrested for the most minor misdemeanor, or if they murder somebody, they all come through General Sessions Court within 60 days, maybe sometimes 90 days, but there's a first appearance usually within 6-7 weeks, or not, if not sooner, actually, much sooner, because the bond needs to be set, or et cetera. And then the preliminary hearing is held at that stage, and then it's bound over to circuit court. In Georgia, I have had cases, and I'm sitting there saying, yep, this is a false arrest, this is BS. But because of the Supreme Court case, HECK, you got to have a favorable outcome, favorable disposition in order to have a false arrest or a malicious prosecution claim. And what I noticed is particularly one set of clients I can think of outside of Savannah. Well, I shouldn't call them clients, but prospective clients. And it had been a year, almost a year and a half. And these are felony charges that they were running a dogfighting ring. And officers that showed up on scene on the property without a warrant, without a search warrant, then went back, tried to get an arrest warrant, come back, and the whole thing is invalid. And why are they sitting on this? And being new to Georgia, I was licensed approximately 2 years ago. I'm learning more about criminal procedure. These DAs sit on these charges intentionally to try to write out. In Georgia, it's a 2-year statute of limitation. In Tennessee, it's 1 year. That is to file a Section 1983 lawsuit, because the statute of limitations for a Section 1983 lawsuit follows in your state what it is for the negligence, a tort, the negligence. In Arkansas, it's a 3-year statute of limitation to file a typical Section 1983 lawsuit. However, in many of these cases, sometimes you may want to file that state claim for assault and battery and false imprisonment against the officer. Well, in the example that I have in Arkansas, it involves a bondsman that raided the wrong motel room, took a guy into custody. And it wasn't even the right guy, and the hotel clerk even says wrong room, but yet he still went through the door. Anyways, but in Arkansas, the statute of limitations on an intentional tort, which would be assault, battery, false imprisonment, et cetera, anything intentional, not negligence, is 1 year. So I got to file that lawsuit for them in federal court, because you can add a state claim on a federal lawsuit through supplemental jurisdiction, and that's a lesson for another day. But if we had waited past November, I could not add those assault and battery claims, because the 1 year intentional tort statute had run. But we could still file the false arrest or malicious prosecution, et cetera, claim, because it's 3 years in Arkansas. Tennessee, 1 year. So think of whatever the statute is for a car wreck lawsuit in your state. That is what the statute of limitation is to file a federal lawsuit. Now, let's say in this situation, I believe in Georgia, I believe it's 2 years on the misdemeanor, 4 years on the felony, but don't hold me to that. I need to look that back up. If the DA tries to,
it is
2 years. So what these DAs may try to do is they might file that accusation or whatever it is to get the criminal case going, maybe 10 days before your 2 years runs. Well, if you're in a situation, you're 3 or 4 months before your 2 years ends, and the prosecutor still has not done anything with your charges, either begin prosecuting them, or file something officially with a court stating they're not going to prosecute, go ahead and file the Section 1983 lawsuit. The federal courts understand the gamesmanship of law enforcement and prosecutors. And what you would do is you file it, stop the clock, that statute of limitation. Now, and then if the defense comes in and tries to say, well, file a motion to dismiss the charges, there's been no favorable outcome, et cetera, et cetera. Now, what you're going to do is you're going to file a motion to administratively close your lawsuit. And what that does is, and that protects the statute of limitations. It's been filed, but we can't have that case sitting on that federal court's docket for another year or two. So what the court will very likely do is they'll administratively close it. The clerk just says, okay, this case is on pause. We're going to administratively close it. That doesn't mean dismiss it. And then when you have if your charges are dismissed, you have a favorable disposition on your charges, you come back in, you file your motion to reopen the case and to go forward. It's extremely important that people understand that. And you and I had a conversation about that on the phone yesterday about your Chatham matter. So, and that's unfortunate that apparently you can't proceed on that. So let me bring up the lawsuit. I'm going to show an example of a lawsuit that I have that would be an example of what you would file. This is my case, Bennett versus City of Adrian, Georgia. I'm not going to talk about the factual specifics of this case because I am subject to certain rules on statements, but this is a public document. This is a public pleading. I'm going to scroll through it so that people, if they want to draft their own lawsuit, they can kind of get an idea of what the lawsuit would look like. Of course, always seek an attorney. This is just for educational purposes. This doesn't constitute legal advice. So this is where you establish who the parties are. Then we establish jurisdiction and venue. Anybody that's watching this on a computer, they can screen record this and or just go to on Pacer. This is a temporary docket number. There's a more, that's what the clerks assign at the very beginning when you file it. So that's not the case docket number. You can go into Pacer in Southern District and look up Bennett versus City of Adrian. So then we have our statement of facts. This was a gentleman that was doing YouTube videos reporting on alleged police misconduct. And all right, here we go. So here, this would be count 1, First Amendment retaliation. This would be your lawsuit. First Amendment protects individuals' right to express free speech, including criticism and objections towards police conduct. Now here, you were trying to exercise free speech, trying to get documents about whatever was going on with city government. It doesn't matter if it's whatever school board officials doing, whatever municipal officials or police, any government misconduct by any agency. It is clearly established that a person has the right to be free from retaliation for exercising their First Amendment freedoms. The reason why such retaliation offends the Constitution is that it threatens to inhibit exercise of the protected right. This is what a person would have to prove in the 11th District. In the 8th Circuit, the 11th Circuit. In the 8th Circuit, it's pretty much the same elements. There's 1 or 2 more, but they're pretty much all the same thing. One, you would have to establish that the speech was constitutionally protected. That's as long as you're on public property and you're doing something in a government forum that's where there's no reasonable expectation of privacy, that first element is going to be easy to meet. The defendant's retaliatory conduct adversely affected the protected speech, and there is a causal connection between the retaliatory actions and the adverse effect on the speech. So obviously, if you're reporting on misconduct and police have a problem with that and they arrest you upon a pretext of a criminal charge, but it's really retaliation, then that would satisfy the second and third prongs. Now, a lot of times people bring up the issue of, well, if a cops can establish the probable cause for the arrest, and in fact you were committing that crime, there's a Supreme Court case, Nieves, Nieves. I'd have to pull up the full name. But that case says no, we're going to carve out an exception that says that if the police do not ordinarily arrest somebody for that specific conduct, and maybe they just issue a citation, then you can still proceed with your case that the actual physical arrest was retaliatory. Now, that's assuming that there was probable cause for the arrest. So let's say here you were loitering, you were conducting disorderly conduct, etc. But let's say they normally issue just a citation for that there. Then through that carve out, that exception in the IBIS, you may try to argue that the arrest was retaliatory. Now, here, I think you just have a full-blown argument that there was no reasonable articulable suspicion to ask for your ID, and that there was no probable cause. It's actually arguable probable cause to arrest you. Something else to remember is that if you try to beat the charge and there's no probable cause on the actual reason that you're arrested for, let's say you defeat the loitering or prowling, but then maybe they try to charge you with obstruction. A lot of people don't realize is if you were well, let me clarify that. If they arrest you on loitering or prowling, but did not charge you and arrest you for obstruction, let's say in an example, the defense attorney representing a municipality or the officer will come and say, well, even though, okay, courts, you say there's no probable cause on the loitering and prowling, there was probable cause. There were facts to support probable cause to arrest him for obstruction, though we didn't arrest him for that. Therefore, the officer is still entitled to qualified immunity. A lot of people don't realize that. All right. Here we put a factual, this is a public pleading. There's nothing wrong with reading from a public document. Investigated and published official misconduct by defendants, which is constitutionally protected activity. Now, retaliatory conduct adversely affects protected speech if the conduct would likely deter a person of ordinary firmness from the exercise of First Amendment rights. Plaintiffs, as persons of ordinary firmness, would be deterred from exercising their First Amendment rights after being falsely arrested without arguable probable. All right. So we had an internet situation there. I think the internet dropped off. I'm here at Jekyll Island at Holiday Inn, doing videos while on vacation. And we were talking about the lawsuit that I have. Give me just a second to bring that back up. Well, I just had it. Where did it go? There we go. There we go. All right. So before we had that internet interruption, we're going through the claims that would be in a lawsuit. Here, a person investigated and published official misconduct by defendants, which is constitutionally protected activity. Then retaliatory conduct adversely affects protected speech if the conduct would likely deter a person from ordinary firmness. And we talked about that. There's a causal connection. There's that paragraph there that we talked about. Defendants retaliated against plaintiffs, seized them and arrested them in retaliation for protected speech. Defendants were acting under the color of state law. That is what's the key to a Section 1983 claim. While searching and arresting plaintiffs, and this was in reckless disregard of plaintiffs' rights. This arrest and seizure of plaintiff deprived them of their liberty, plaintiffs. The defendants were acting under the color of state law while on scene, participating in the unlawful arrest of plaintiffs, and this was in reckless disregard of plaintiffs' rights. This arrest and seizure of plaintiffs deprived plaintiff of their liberty. And this is the key. No objective, reasonable police officer would have had reason to believe they had authority to conduct a seizure, investigatory detention, and/or arrest of a person under the totality of these circumstances. That is the test for defeating qualified immunity. Qualified immunity is all based upon an objective standard. What would a reasonable officer have done in the circumstances of when, let's say in your circumstances, And that's what it's judged by. And then on count 2, we have unlawful seizure, false arrest, violation of Fourth Amendment, all defendants. I'll just scroll through here so people can kind of see what the legal elements or language of that would be. And then we have a count 3, municipal liability Monell claim, which in a lot of my lawsuits now, I'm just not adding these because they're just so difficult to defeat. But in this situation, we believe it's applicable. And then this is the common law claims that we have: assault and battery and false imprisonment that we added. So, well, listen, this video has gone on a very long time. If we get one person or subscriber to watch this whole thing, that will be an achievement. But I hope this is great value, and I hope that you've learned from this, Russell. And that's kind of concludes it for me. Do you have anything else to add?
Not at the moment, no. Just like, share, subscribe. Go check out Mumford Law, his YouTube channel.
Same for Georgia Transparency. I really appreciate it, my friend.
Yeah, great guy, great person. Look forward to working with you in the future.
All right, my friend. Have a great day. Take care.
You as well, sir. Thank you.